My name is Cynthia Mason. I'm a Canadian trademark lawyer with the law firm of Mason PC and with our online trademark registration platform, Markably. In this video, I want to share a little advice that came to mind when I read about a recent case involving a Dallas Mavericks basketball player who was involved in a fairly high-profile trademark dispute with his mother. The dispute came about because earlier in his career, he had allowed his mother to register his name as a trademark for merchandise. As he grew in fame, he wanted to register additional trademarks, but this earlier trademark registration was blocking his later marks from going through. And his mother refused to give up the trademark registration. And that led to a dispute, which he ultimately abandoned, which basically resulted in his trademark applications, his later filed trademark applications going abandoned. But what this case, I mean, while it's extreme, nobody should be really arguing with their mother about trademarks, but what this case really illustrates is something that happens all the time when business partners or co-founders don't have a plan in place with regards to who owns the trademarks used by the business. Now, if that business relationship breaks down, which clearly something happened between this player and his mother that resulted in there not being an agreement going forward, but when a business relationship breaks down, and we've seen this happen many times, including between other family members, not mothers and children, but other family members for sure, what typically happens is that then there's a race between the business partners to set up a competing business using the same name or logo, or they rush to file a trademark application if there wasn't one already on file, but they rush to file a trademark application, which gives them a procedural advantage in terms of registering names and logos as trademarks, and a trademark registration gives them the exclusive right to use those properties going forward. Now, if you want to avoid this free-for-all or this race to the bottom, really, there is a very simple solution, and it does not require that you have any sort of agreement in place with your co-founders or your business partners. That solution is to really just make sure that the business registers the name and logo as trademarks of the business. So when I'm talking about the business, I'm talking about it as a separate legal entity from the co-founding business partners or the business partners who are operating it. Now, if the business is incorporated, the corporation should be the one who owns the trademarks. If it's an unincorporated partnership between individuals, the partnership should still be named as the owner of the trademarks. And what this does is that this trademark registration filed previously in the name of the business keeps those trademarks from being up for grabs by any one business partner or founder.